This is Patrick Henry, the CEO of QuestFusion with The Real Deal, What Matters. We're here today with Mike Van Loy. Mike is a patent attorney, and he's a member of the intellectual property section of the law firm of Mintz Levin. His practice focuses on all aspects of intellectual property or IP strategy, which includes development of IP portfolios, investigation of patentability, drafting and prosecution of patent and trademark applications, patent infringement, preparation and support for patent litigation, licensing negotiations, and monetization strategies for IP portfolios. Mike drafts and prosecutes patents and advises clients on IP issues in a wide variety of technical fields in the technology and life science areas. He also represents investors in early stage companies with assessing the strength and value of these companies' IP portfolios. He has his bachelor's degree in chemistry and his PhD in environmental engineering from the University of California, Berkeley, go Bears, and his law degree from Santa Clara University. Mike was named a San Diego Super Lawyer Rising Star for Intellectual Property in 2016. Welcome, Mike.
Hi, Patrick. Nice to be here.
Mike told me before we turned the cameras on that he actually went to Patrick Henry High School, so we have some connection there, I suppose.
It's a very small one.
So let's get right into it. What is a U.S. utility patent, and what isn't it?
So any patent is basically a monopoly right that's granted to an inventor or set of inventors, and can be assigned to another entity like a company. That intellectual property right is basically the right to exclude others from making, using, buying, or importing the protected technology within the country that the patent's issued in. So a U.S. utility patent basically allows its owner to sue others for patent infringement if they do one of those four activities relative to what's covered by the patent.
Okay. So when I was, running tech companies, we had this strategy where we would patent stuff in the U.S., and that was kind of the most valuable aspect of patenting, but then we had to patent stuff in Europe and sometimes in China or Korea or different places where we sold because they all had their own patent, capabilities or, laws or whatever it was. What do you think the best strategy is for, especially a startup, when they're getting involved in, starting to protect their intellectual property with patents? I've heard about checkerboarding, and if you have multiple patents, you use some in certain areas. But what do you typically advise clients and those kinds of things? Because it can get pretty expensive.
Oh, it can get extremely expensive. So I've seen an estimate for the sort of total potential spend for a patent that you wanted to protect in, say, the five biggest economies in the world. If you said like Europe, China, Japan, Korea, the U.S., obviously, the total lifetime spend on that patent might be $250,000.
Wow.
So, and of that, maybe $15,000 to maybe $25,000 might be your drafting of the application, your filing fees in the U.S., and prosecuting it and getting it issued in the U.S. So your bang for your buck with the United States is very high. The filing fees aren't they aren't out of control. For a small company, it's $800 to file the application. Assuming you get it, you may pay another $1,000 to $1,500 in fees before you get the patent issued. Your attorney fees, depending on the complexity of the invention, might be sometimes in the single-digit thousands. But if you want to really, depending on the technology and what it covers, you're probably looking at spending somewhere between 8 and 12 to 15 on attorney fees to get it drafted, and then maybe that much again dealing with the patent office to get it done.
Okay.
So for a small company with a limited budget, sometimes I have clients that come in and say, "Hey, I want to protect this everywhere."
Yeah.
And then you explain to them how much that's going to cost, and they go, "Well, maybe not."
Yeah.
There is a strategy at the end of your, so you have 1 year from your first filing to make a decision on whether you're going to file outside the U.S.
Okay.
One option is to file what's called a patent cooperation treaty application, which is about $4,000, and that effect of that $4,000 basically buys you the right to wait another year and a half past that 1 year deadline before you start spending real money.
Okay.
So sometimes if you have if you have a patent that you consider to be fundamental to your business, if it really is one of those, if you don't have this barrier, then any old person who shows up can just copy what you're doing and run with it. It might be worth at least filing that PCT application to have the opportunity to, hopefully things go really well in a year and a half. You're ready to move. and if you don't, you have to make that decision. So it's it's one of those boxes that investors like to see checked. You'll get a question that says, what are the barriers to a competitor stealing what you're doing and running with it? One way to say that is, hey, we have patent protection on this. We've filed a PCT application. We have the option to file internationally. A lot of it depends on what stage you're at. But certainly, I've never heard of a company, even like some of the largest pharmaceutical companies might try to patent something in every country in the world.
Sure.
But most of the time what you refer to as checkerboarding is effectively having enough large markets covered that you can, potentially someone who wants to infringe or wants to do the same thing, they could say, well, okay, I can't do it in the U.S. I can't do any of those activities in the U.S. I can't do any of those activities in Europe. I can't do any of those activities in China. Maybe I should take a license worldwide.
Yeah.
So if you have enough barriers there and you've closed off enough markets, it may be worth it to someone to ask you for a license, or if they're going to try to avoid your patents, they're going to have a much reduced market.
So if somebody's infringing, they have to infringe by selling into a geography where you have patent protection. Is that how it works?
Well, it's any of those four activities. So making, using, selling, or importing. So
Okay.
A U.S. patent actually does reach outside the U.S. because if you have, if somebody makes a competing product in China and tries to import it to the U.S., they can certainly make it and sell it in China.
Mm-hmm.
You'd have no recourse. But if
Okay.
they make it in China and bring it to the U.S., you can actually you potentially can have the customs service intercept it at the border.
Okay.
This is called the International Trade Commission. It's an ITC matter. You can basically sue. It's a very rapid trial. It takes about a year. If you win, the Customs Service basically will interdict infringing goods at the border and destroy them.
Okay.
So it can be quite powerful. You can, and then again, if you make it in the U.S. and ship it elsewhere, you've got that. If you just use it here, so internet patents that rely on sort of a networked situation or the internet, even if the server's offshore somewhere, if they have customers in the U.S., they're infringing.
Okay.
As long as your claims are written the right way.
Okay. So talk to me a little bit about claims. Why is it important to get them right, and how do you make sure they're comprehensive? And I guess there's always this struggle about being specific, but also being broad enough that you kind of cover everything, so somebody can't just like patent around it. I mean, I remember goes back a couple of decades, but I don't know if it was a bunch of Japanese companies or Korean companies, but they would basically have a U.S. company that had a basic patent, but then they would do all this patenting around it and be able to make products that, you would have to take a license from them because, you had to do both things or multiple things in order to actually build the product.
Right. So there's two questions in there. So the issue of sort of circling around a patent or having a sort of improvement on an existing patent, that's a situation that you can end up in if you're a competitor and somebody has a fundamental patent that sort of has some core technology that you need in your product.
Sure.
If you have some improvements on that still rely on the original underlying patent, you may be able to patent the improvement because you don't actually have to. Having a patent doesn't give you a license to actually practice the invention yourself. It's not a guarantee that somebody else doesn't have an underlying patent that you also infringe.
Okay.
So the situation that you described where there's a sort of a fundamental patent that may be fairly broad, but then I can patent something that's more specific within that broad coverage of the original patent. So if two different entities own those two patents and they want to make the improved version of something, the entity that patented the improvement would need a license to the folks who had the original patent.
Okay.
And the folks who had the original patent would have to come and get a license from the people with the improvement.
Okay.
So you end up with sort of a cross-licensing issue. That happens a lot with large companies. That's one reason that large companies tend to accumulate a lot of what I would characterize as sometimes fairly incremental patents.
Yeah.
They have patent incentive programs. They encourage their engineers to come up with ideas and patent them, and they tend to be fairly. Sometimes you look at a whole suite of them and you say these are the same thing.
Yeah.
But what it means is if they get sued by another competitor for patent infringement, the competitor might come at them with 6 or 8 or 10 patents. You rarely want to go into litigation with one patent. That's like going to war with one bullet. Because one patent, your opponent may say, okay, we can fight that, or we can go to the patent office. There's procedures at the patent office to be able to argue that the patent shouldn't have been issued and is invalid. So if you just have one patent, they may go do that. and then you're stuck. But you have 10, and each one of these procedures at the patent office is not cheap. So
Yeah.
if you have 10 of them, they have to go and try and invalidate 10 patents.
Okay.
And if I have 10 patents, they come at me with 10, and I say, well, guess what? I have 15 that read on what you're doing. You're quickly going to get to a situation where you say, okay, why don't we just all cross-license and stop paying the attorney so much.
Okay.
But getting back to claims, so the claims are the only part of the patent that actually dictates what is covered by the patent. You can kind of they're a textual outline of what the sort of boundaries of the intellectual property space that is protected are. So you can kind of, if you think of intellectual property in terms of like ranch land, rancher number one has a fence around what he owns.
Yeah.
In patent speak, his claims would describe in words what the boundaries are that he's protecting.
Okay.
In order for you to get that patent, those words that you use to describe your little fenced-off area have to be specific enough that the prior art, which means other things that were done prior to things that had things that were in the public domain prior to your filing of your patent. You need to be able to show that your little area that you're trying to claim has not been done, and none of that's covered by something that's been done before.
Okay.
So, ideally, you'd like to write your claim very broadly and cover lots and lots of stuff, because then if you have a very broad patent, you have a lot of potential infringers. It's a very powerful patent. On the flip side, you've got all this space that you're trying to hold. It only takes somebody finding one other thing that's inside of that original space to say, hey, that patent's not valid.
Okay.
So there's a little bit of a tension there between you want a nice. People will say, I have a nice strong patent. It's very broad. Well, you may have a lot of infringers, but you also have some risk that it's not valid. So the other side of that is it's very narrow, meaning it's got a lot of detail in the claims. The claims go on for a long time. It may not have as many infringers, but it's going to be much harder for somebody to show that something in the space that I'm protecting was covered before.
Okay.
So, and there's a way. So the claims typically it's a little bit. Sometimes I get inventors who look and they go, "Oh, this claim's not very long. It doesn't cover anything." I say, well, the breadth of a claim is inversely proportional to how long it is. The more words there are and the more details, the more sort of you've cut into what space you have. Because for someone to not infringe a claim, they just have to show that they don't do one of the things that's required by the claim. So if your claim requires somebody to do operations A, B, C, and D, and they say, well, I do A, B, and C, but I don't do D, they don't infringe.
Okay.
And again, if you want to show that the patent's invalid, if you want to say that claim's invalid, you would have to find something in the prior art that either makes each of those elements, A, B, C, D, and E, or A, B, C, and D, has to show that they were done before and that they were either known or obvious. That it was a trivial modification of what was done before. So yeah, the claims are pretty much crucial. I see lots of patents that, the format of a patent application is generally a description that runs through what the invention is, maybe a little bit of a discussion of what kind of problem you're solving. For various reasons under U.S. patent law, you don't like to necessarily lay out specifically what the problem is, because then if your technology ends up solving a different problem, an infringer might argue that it doesn't really cover what they're doing. Okay. But so you sort of at a high level you run through what the problem is or what the background, why you're an improvement over what was done before. Then a fairly technical and reasonably specific description of what it is that you do and some other alternatives to that you think would be workarounds, and then some claims that. They're written in English. Claims are basically a claim is like one long sentence that looks kind of dense. It's written kind of in a strange syntax, but it basically lays out sort of all the elements that you consider to be within your invention, and it would be required by an infringer. Okay,
cool. So when we, had, and this is multiple different tech companies I've run, we would, but especially if they were small, we would file provisional patents. And then we didn't have to, I guess that was a way to at least get our invention on the books, but not spend as much money. And during that period of time, you could add additional claims to your potential patent. Has that changed now, or kind of what's the current state of the art of what people are doing as far as startups go?
Provisional applications are still an option. It basically, you got it mostly right. A provisional doesn't require, a provisional application is never formally examined. So what it is basically a technical disclosure of your invention, and it can be, there's no requirement that it have anything. I've seen provisionals that were basically scrawled on the back of a napkin.
Okay.
The Patent Office will never look at it. It will get filed. You have a year from your first filing date of that provisional application in order to file a utility application to have it mean anything. If you don't do anything, if you don't file something within a year that claims priority back to the provisional just goes away like it never happened.
Okay.
It goes off to, I envision it getting put in one of those crates that you see them wheeling off at the end of Raiders of the Lost Ark. It goes off into the warehouse and nobody ever sees it again. Probably doesn't happen anymore. It probably just goes to some dark corner of the internet, of the Patent Office's intranet, and never gets seen. But that said, while you can file something that's very scant as a provisional application, there's a risk, because in order to, like I said, the Patent Office will probably not look at your provisional application. In some instances, I've seen examiners look at the provisional application if they find intervening prior art. So say you filed a provisional application today, or say May 1st of 2016, and then you didn't file your utility application until May 1st of 2017. But maybe there's somebody else published something 6 months from now, which, if you were entitled to the priority date of your provisional application, would not be prior art. You predated it. However, if your provisional application is so vague or lacks the details necessary to write a claim that's actually allowable, and if somebody could argue that, you didn't really describe what you're claiming here in the utility application until you filed it, that prior art that was intervening could actually come and get you.
Okay.
So I usually recommend, it's certainly, we can take just some technical document that an inventor gives us and just file it as is. I usually don't recommend that.
Okay.
Just because it helps to at least take one pass through. Let's have a conversation about what we think we're going to claim and what we think the important things are. And let's make sure that we at least have description around that.
Okay.
Typically, when somebody gives you a disclosure, it's very easy to describe sort of the problem, or, here, I can give you a whole, chapter and a half on what we do.
Yeah.
But where's the interesting stuff? You need really the details around the stuff that your secret sauce, what makes you new and different.
Okay.
Otherwise, you run the risk that when you write your application later, it may not be entitled to that earlier.
So the value of putting the stake in the ground really isn't that valuable unless you at least have some reasonable description of claims.
Yes, and while that's an issue in the U.S., the U.S. has a fairly liberal interpretation of what amounts to sufficient disclosure.
Yeah.
So I can have some pictures, I can have some, few words here and there, and I could file something, 9 months later and argue that, well, it's all there. You could sort of, it meets the sniff test, and that seems reasonable. Most other countries, especially Europe, China, I think Japan's got a fairly tight rule as well. If you can't show actual textual support for what you've claimed, like, you can probably conjugate the verbs differently. But you better be able to show that it was absolutely clear, if not quite literal, it needs to be pretty close to literal textual support for your early date in order to be able to have it. So if you file a fairly vague provisional application, and then you even start doing things yourself, an examiner may argue that your original disclosure document was not sufficient to support the claims that you've made, and that your activities in between the provisional and your utility filing date were sufficient to cause prior art.
Okay.
Because most other countries outside the U.S. don't have a 1-year grace period. The U.S., your own activities, by and large, it changed a little bit with the America Invents Act in 2013, but by and large, most activities by the applicant themselves that are less than a year before the utility filing date don't amount to prior art. That law still a little bit. They changed some things with the law, and there haven't been a whole lot of court cases that have established it. But assuming that things fall out mostly the way they did prior, it's better to file something before you start doing it.
Okay.
Before you disclose it, but we can file within that year. It just adds a little bit of uncertainty, which we don't like.
Okay. So I've heard that the U.S. Patent and Trademark Office is backed up for 7 years or more. Is that true, or is that there's certain pockets, or what's the deal there?
There certainly are. So the term is art unit. They divide the patent office up into sort of groups of examiners who handle very sort of similar technology.
Okay.
And 7 years is probably a bit on the long side. I've got it for a while, maybe 5 years ago, it seemed like you would file something and you'd wait many, many years. I do have some that I'm still working on some patent applications, trying to get them through the patent office, that have been on file since like the mid-aughts. 2005, 2007.
Wow.
Most of those have at least had one. I can't remember the longest I had before one actually got examined. These days, in most art units that I deal with, it seems like they'll get a first office action out within less than 18 months. Usually.
Okay.
So it's gotten better. They hired a lot of examiners. There's certainly, in certain areas now, there's a lot more uncertainty with software patents because of some court decisions of late, which makes it easier for the examiners to issue a rejection because they can say, oh, here it's not eligible for patenting because of this rule.
Okay.
And they've been encouraged in the last 5 years or so to really work hard at cutting down the backlog.
Okay. So I guess there has, along those lines, there's been some recent changes about patents. How does that affect the importance of filing dates and invention dates and, those types of things?
So the two main things that have changed in the last, say, 3 or 4 years. There was the America Invents Act, which took full effect in March of 2013, which officially changed the United States from what we used to be a first-to-invent jurisdiction to a first-to-file jurisdiction. By first to invent, under the old regime, if you filed a patent application, your priority date was actually technically the date that you invented the invention.
So this is like all the engineers that I used to work with, they had their little books, and as long as they documented that was the prior art, even if it didn't get filed for a couple years after they did the initial invention.
Well, in theory, doing that would have given you the opportunity. If you filed your application, say now, let's say I filed an application today, I can document that I actually invented it 6 months ago. If the patent office came up and said, oh, there was prior art that was published in January of this year, and you say, oh, well, our guys actually invented it before that, so we can, you could file a declaration, have the inventors put their notebooks into evidence and say, look, we actually invented this before that, we predate it, we're okay. You could only go back a year. I mean, if the patent office found prior art that was available for more than a year before your filing date, you were pretty much done.
Okay.
But there was some ability to sort of say, oh, no, we actually invented this prior, and there was a delay in getting it filed. Now the official rule is the date of invention is not the determiner of the date of filing.
Okay.
There are these exceptions for sort of the applicant's own activities, either the inventor or somebody that they have an obligation to assign it to. So their company, if they publish something and then file within a year, their activity is not prior art. If they publish something and then somebody else sort of republishes it, and it's clear that it was derived directly from what was originally disclosed by the company, that also should not qualify as prior art. Under the old regime, there was a procedure known as an interference, which meant so beyond things being prior art, there's the theory where two different groups file patent applications on the same thing, two different companies. Okay. And then you would have this little mini trial that would determine who actually invented it first. Those have gone away. Interferences are still valid for anything filed before March of 2013. Now they actually have what they call a derivation proceeding, which is, well, you filed first, but you actually sort of effectively stole it from me. Okay. So the burden's a little different. That said, in 15 years of practicing, I have never had any patent application that went to an interference. Okay. They're horrendously expensive. So while the theory was, there was all this gnashing of teeth with the American Invents Act, that it was, it's making it harder on small inventors. And, we've now made it so whoever has the most resources and can file first wins. The truth of it is, under the old regime, if you were a small company and you got stuck in a situation where you had to try and fight an interference out with a big company, you were done. You're not doing it. So I don't think it actually changed very much. The rules changed, but the reality on the ground didn't change very much.
Okay. And then how do you tell if a patent's actually being infringed? How is it detectable? I mean, is that easy in some ways, and other ways it's hard?
Well, it depends, and that's why certain types of patents are certainly easier to detect. So if you have a patent that protects a lot of the say it's something on some sort of mobile commerce situation where I can say, look, I can look at a competitor's app and say, look, they take this, and then that must go to the back end, and something happens, and then a result comes out, and I can pretty well map. It's clear that what they're doing must fit on the claims that I wrote or that we have. Mm-hmm. Typically, the way you sort of start a potential argument about somebody infringing is first you send them a letter and say, here, we think you should be aware of this patent. Oftentimes you'll get no response, or they might write back and say, no, we don't, tell us why. And then you would basically put together a claim chart, which takes your claim, on one side of the column, and then basically walks through. Here's what we claim. Here's the element we claimed. Here's what we think you're doing that fits it. There are certainly a whole class of, if it's a physical object, if they're selling it, you can buy it, take it apart, see what's in it. There are situations where, there are things that you may not want to actually bother patenting. If it's a back-end process that's fairly opaque, kind of a black box that data goes in and something happens, and we've got some sort of unique little data structure. Patenting that may not actually be worth very much because in order for you to get a patent on it, you've got to write a whole description of it and share it with the world. Once your patent issues or once your patent is published, there'll be a nice little recipe on how to do that. And then if you even get the patent to issue, your competitor, they may have on the front end, they may have some data that comes in and out. You don't know what's going. If you can't from seeing what's publicly available, you can't actually tell with certainty that what's going on behind the curtain is what you did. Then you can certainly file suit. You can do some investigating. But you may be sort of in a gray zone there where you can't really figure out whether there's true infringement or not. Until you file your lawsuit, which costs money, and then the other side may say no, we don't. That's not it. We don't do that.
So those are things that might be better to keep it as a trade secret.
It's certainly worth considering. I mean, if it's a internal process, if it's something we do, I've got big clients who do this too. They say, look, if this is something that just helps us do a better job of putting our code together, you're never going to know if somebody, unless they share it, unless company A has this process and company B comes along and says, oh, we do the same thing. And that's unlikely that somebody's going to share that.
Then tell me a little bit about the importance of who gets named on a patent. Who the inventors are. Is that important to the company, or is it just important to individuals, or how does that work?
Well, it depends. I mean, some companies, especially startups, some of them don't have an incentive program. A lot of larger companies do. They say you get a cash payout or something like that. Some startups will say we'll give you some extra options if you're inventing core technologies. Inventorship is supposed to, there's actually a legal standard for it, although it's fuzzy. It's, inventor should be somebody who contributed, had a meaningful contribution to some feature that's included in the claims. But that can be, what's meaningful, 6 or 8 guys are sitting here, 6 or 8 engineers are sitting around a table, and, 5 or 6 of them are talking. There's one person at the whiteboard. Maybe she's going crazy, and 3 other guys throw out, hey, do this and that and the other thing, and then somebody else is just sort of sitting there nodding, or maybe they throw out one idea. It's these brainstorming sessions become it's very fluid and it's very uncertain who invented what. So typically, if there's a group and they're sort of doing brainstorming, you may just say, look, you're all inventors. Where you can get into trouble is, and I have companies that say this, it's like, oh, well, he's left the company, he shouldn't be an inventor. And I say, well, that's we need that. That's actually not the legal standard. We don't like him anymore, or she went to a competitor is not a good reason to say they're not an inventor. Because the reason for this is you may cut them out, you may file your patent application, you may get your patent. 5 years down the line, your patent may be, your company's going great, you've got this patent, you file suit against somebody for infringing, and they find this person who left, and they say, well, she said, she was contributed to that, and you didn't list her as an inventor. So the patent, either you need to add her as an inventor, in which case every inventor to a patent, if they don't assign their rights, has the right, they're all joint and several owners of it, the entire patent. So, she may be an inventor, and she has the right, we can go to her and get a license. Or the patent's just straight out invalid because you didn't name the inventorship right. So the safest thing to do is, if anyone who's in that circle where you say, they're probably an inventor. There's a form you file, all the inventors sign what's called an inventor declaration that basically says, I believe I'm an inventor of subject matter that's claimed in this patent application. So you've got them under oath saying, I believe I'm an inventor. And typically, if your company was set up right and you have the right employment policies, you've got some either formal, or you're either relying on, if you're in the state of California and they're a technical person, they're basically hired to invent. Their obligation is to assign to the company. You sometimes end up with these sort of independent contractor situations where I'm not an employee, so maybe I don't fall under that rule. But you better make sure that your contractor agreement has something in there about
Right.
who owns the IP.
Yeah.
So assuming you have all that, the safest thing to do is name anyone who has some reasonable proximity to that inventive nexus.
Yeah.
Make sure they sign a declaration. Get them to sign a formal assignment to the company.
Okay.
Because then, 5 years down the line, you try to have this argument about I wasn't an inventor. You say, the first exhibit 1 during their deposition is, what's this? It's a declaration.
Yeah.
Is that your signature? Yes. What does it say? It says, I believe I was an inventor. So are you lying then or are you lying now, right?
Yeah.
So it's slightly bigger tent is probably safer.
Okay. Cool.
That said, sometimes you get folks like, oh yeah, he's a really good guy. He's an inventor. Like, well, you don't want to stretch that so far that every person who's been at the company for the last 2 years is an inventor on everything.
Right.
It can go the other way, but I tend to err on the side of, well, unless you were someone who just sort of took direction and they say, here, go code this, and all you do is sort of take it and code some aspect of it.
Sure.
That's not an inventor. But if you were in that original, let's figure out how to solve the problem conversations,
Yeah.
you're probably an inventor.
Okay. So talk to me a little bit about, what is a trade secret? Is there a formal definition of it, and what are the pros and cons of keeping something as a trade secret versus patenting it? You talked a little bit about that earlier, but are there other things that come to mind?
Well, a trade secret is basically it's something that's has value that is in the public domain, and that a company, for it to be a company's trade secret, they have to basically take some steps to mark it as secret and keep it secret.
Okay.
A trade secret only has your only real cause of action with a trade secret if somebody else gets it is if they stole it. So if somebody buys your product and manages to reverse engineer how you did it, not a trade secret anymore. If somebody else independently comes up with the same idea, you have no recourse.
Mm-hmm.
So all you really have in that trade secret is you have to basically show that somebody stole it from you. So it tends to get used, employee leaves, and you say, well, suddenly all of a sudden this technology has now showed up in the competitor product that they went to.
Okay.
You may say, hey, guess what? You signed this agreement, and you're obliged to not share it.
Right.
And you did. Those tend to get really ugly because they're very very fact dependent, right? It's was it actually? And California has fairly strong employee protection laws. We're very very anti competition state. So
Yeah.
saying that I left a company, I went to work for somebody else. It doesn't matter if I signed a non-competition agreement.
Right.
You're probably company A is not going to have it's going to have a tough time preventing you from going to company B. There may be some dickering about what from here is now there, and certainly going to be an argument, but the presumption is that you're free to go someplace else.
Okay. So basically, a trade secret, you have to document it, and the only protections are if you can prove that somebody stole it and is using it somewhere else.
Right.
Okay.
So there's a risk, but again, a trade secret doesn't expire. Patent expires.
Yeah.
And a patent, there's that exchange with a patent where I have to file a patent application, and I have to effectively describe in sufficient detail what I plan to claim. There's a possibility I don't get the patent, in which case I've just shared everything with the world.
Yeah.
In the U.S., you can actually file your patent application with a request not to publish it until it's issued, but you can only do that if you're staying in the U.S. only. If you decide you're going to file internationally, you can't avoid publishing it. It will be published 18 months after the first priority date.
Okay.
So,
Is that another reason to do that kind of extension thing, kind of keep it secret? So you do a provisional, that gives you a year, then once you actually do your utility patent, then you have a year, then you can pay that money to extend it by another year, or how does all that work?
well, the publication is 18 months from first priority. So in the situation where you file a provisional and then don't file your utility until a year later, it's going to publish 6 months after your utility application. And if you file the PCT application, you'd have to do that at the 1 year mark as well. If you filed your U.S. utility application earlier and requested non-publication, when you file that international application, you have 45 days, and it's a hard 45-day deadline to let the patent office know, effectively to rescind the non-publication, or else your U.S. application is abandoned.
Oh, wow.
So it's one of those where you go, are you sure? And then, okay, we make sure that we've got a little flag in the file that says, okay, now we filed internationally, we have to make sure we let the patent office know.
Right, okay. So what about software? I mean, you mentioned it a little bit earlier, and I know when we had different companies where there was a lot of code, we could say it was copyrighted, but I don't ever recall us like patenting anything in software unless there was like, might be like an algorithm that we had that then we would code in software and we could patent the algorithm, but the software itself we could never like patent. I mean, what's the deal with that?
So a copyright immediately jumps into being as soon as you create a new work of anything. So
Okay.
If I write a story, it's copyrighted the moment I write it. You can register the copyright with the Copyright Office for some fee, which basically allows you to recover statutory damages. It means you don't have to show loss.
Okay.
You can just say, I have this work, original work that's mine. I'm copyrighted it. If somebody copies it, then they owe me some fixed royalty for every incident of copying.
Yeah.
That said, so if I write, I have some software, I write code out. If somebody looks at what my software does and says, that's pretty cool, I'm going to give it to my coders and say, here, don't look at the code, just write up something that does this. Mm-hmm. Their code is not infringing the copyright. The code is actually on the specific.
They have to rip it off kind of line by line.
Yeah, it has to. In order to show copyright infringement, you actually have to show that it's a copy.
Yeah.
Or it's either a copy, or you can. There's some issues where you say, well, it's a very close derivation. I took that and I maybe added a little bit to
Sure.
it. But by and large, you're looking at a copying issue. So there is an option. So you can certainly file. There's plenty of software patents that get filed. They have become harder to get. There's a whole area of patent law that for the last 15 or so years, probably longer than that, sort of business process patents. So it's taking, a lot of them boiled down to, well, here's some sort of economic something or other that we've now automated.
Yeah.
I have code that basically, I take instead of having a pad of sales orders and writing them out, I go online and I do it. And there are lots of patents that cover that kind of stuff, a new portal for taking that data and putting it in and making an automated sales order process. Those patents have become harder to get, and the ones that were issued in the last 10 or 15 years, many of them are probably invalid. There was a Supreme Court decision just about 2 years ago, 2014, June of 2014, called Alice versus CLS Bank. The Supreme Court, and honestly, the claims at issue in Alice versus CLS Bank were not terribly well written. As with most patent law court decisions come down to, gosh, that's a terrible patent. I mean, those are the things that are very vague and very hard. There's a lot of money involved. They're the ones that get fought all the way up to the Supreme Court. And the Supreme Court they're not patent lawyers.
Yeah.
They're smart people. This particular one, basically the decision was these claims in the patent issue were too abstract. They effectively just sort of claimed an idea without having something significantly more involved with the idea.
Okay.
I forget, there was another one called Bilski, but they basically, one of them had to do with escrow payments, effectively automating the escrow process.
Okay.
And it was a high-speed trading escrow process, right? So it was like, take the stuff, hold it here, and the other one was, I forget what it was off the top of my head. But again, sort of what was considered to be a fundamental economic practice that was just being automated.
Okay.
So that decision happened in 2014. The lower courts, the Court of Appeals for the Federal Circuit, which is the federal appeals court for all patent decisions, has heard something like a dozen cases since then that involve this same sort of question. And of those dozen or so cases, there's been one case that they've held that the patent was valid.
Okay.
So, that trickles back down. The lower courts are like, software patents are in doubt. And some people will say, software is not patentable anymore. The Alice decision was not a terribly lengthy decision. Justice Thomas is a fairly economical writer. He wrote the decision. Even then, it was still a 10, 15-page decision.
Yeah.
If he'd wanted to say, if the court had agreed that software was not patentable, he could have been really economical. It would have been, this is an invalid patent because it patents software and software is not patentable. So some software is patentable, and I have clients that, in the database space, and if you can show that your claims are tied to some technical underpinning, it's not just automating some. If you read the claim and you say, this sounds like I could do it, albeit a lot slower. I could do it with pen and paper or by thinking about it. Even if it would say, I could do pen and paper, I could use 10 million legal pads in 20 years, but I could still get to the answer. Chances are your patent is probably not valid.
Okay.
But then there's a lot of stuff in the computer implemented invention space. A lot of database technologies, certainly a lot of networking. If you have hooks that requires that it be on a mobile device, if there's a user interface, those kind of things tend to, under U.S. law currently, tend to be they tend to get you over that first hump. So what Alice did was add a more substantial first hurdle before you got to sort of arguing about the prior art. It was, is this something that should be eligible for patenting?
Okay.
And in the past that had been, well, is it useful? Okay. There was not that first hurdle was not there.
Okay.
So now that is a substantive question. Is it something that's eligible for patenting in the first place?
So the first hurdle is basically you're not just automating something that's already done a particular way.
Yeah. That said, the law is very much in flux. The Patent Office has issued, I think now, 4. They just last week will actually be issuing another alert for clients here in the next couple of days. But they keep trying to tell their examiners how to examine patents. Yeah. Because frankly, the test is a mess. There's really no bright line rule. It's this is directed to an abstract idea. Okay, so here's a further analysis, which is not really smart. I mean, judges are really smart. Yeah. A lot of really smart lawyers. I think you got 100 of those people in a room and said, here's a patent. Is it eligible or not? You'd get, depending on the patent, you might get 60-40, 50-50. Wow. And it's very fact dependent. It's very examiner dependent when you're dealing with the patent office.
Okay, interesting.
And I've seen analysis that says, 2 patents that sound very much, technologically they're very similar, but they just got classified into different groups. Yeah. Maybe one sounded a little bit more economic practices like, and it got sent to this group that examines that kind of stuff, versus another one that maybe got sent over to the database group. Yeah. The economic practices group tends to be very unfriendly toward, everything gets an Alice-based rejection. And very similar sounding claims that went over here to the database guys, who just sort of assume that it's, of course, you have to have a computer involved. How are you doing this? Those tend to go right through. Okay. No problem. So there's going to be a lot more to come. It's certainly not settled. But that said, we get things a lot all the time that are, you could characterize as entirely software. But it's just a matter of making sure that it's very clear that you're on the specific details of, what problem you're solving, what technological. I saw a court case that basically characterized it as things that are sort of inventions that you could characterize as entrepreneurial in nature. Sort of, hey, this would be cool if we did this kind of business model, versus something that's technological in nature. Those first group are going to be harder to patent than the ones that you can clearly say, this is, there's computers talking to each other and they're integral to the whole process, and it required some clever something or other in the architecture or whatever else to make it work. Okay, interesting.
So as a small company, like early in my career, I worked with big companies, and some of them had, big legal staffs, that would be out there, going after small companies or even other big companies about, hey, you're violating our patents. And there was a lot of cross-licensing going on. And, I remember Texas Instruments, there was one quarter where I think their whole overall profits were based on, their IP licensing business. But as a small company, you can't really afford to have that. It's more of a defensive type of strategy. So, I mean, when you're working with small companies and, you're working with them on getting patents, I mean, what advice do you give them? I mean, you mentioned, hey, don't just have one patent, get half a dozen patents, so that you have, some defensive capability. But beyond that, what are other things that you would, counsel small companies on, that are like, hey, we can license this to everybody in the event that, we can't make a product?
As a small company, your market for trying to license something is going to be small. Yeah. So, if you're going that route, chances are what's going to happen is after your company stops being viable, what are called non-practicing entities, some group will come along. We don't like to use that word. A hedge fund or somebody else who's assembling a portfolio will sort of buy your patents for not a lot relative to what you think they're worth. and they'll bundle them up with a bunch of other patents that are sort of similar, and then they'll go to various folks and say, hey, you should take a license to this.
Yeah.
And there are groups set up to do that very efficiently.
Yeah.
A typical startup, if that's your business model, you need to start with most of those groups that are going and doing that licensing work are not they aren't doing the patents themselves. They're buying them up at bargain basement prices from
Right.
other folks who had them and
Right.
can't afford them or don't need them or have pivoted somewhere else.
Yeah.
So as far as creating your startup strategy, you need something, because your investors are going to say why do I give you money when unless you can show me that there's some reason why, once this gets viable and once you start making money, that's when people are going to start copying you, right?
Right.
As a startup, you certainly, I sometimes get folks, we got this patent issue, we got to go sue everybody, and I go, no, you don't. What do you do? All you're going to, if you start a lawsuit, that just means you're going to, do you have a spare several $1 million to go fight a patent or litigation? No. You want them there in case, big company comes along and says, oh, that's an interesting little thing.
Yeah.
And they've built a nice market. We should pay them. And oh, by the way, they have a nice fence around it, so that's even better. I think the key is to just sort of sit down and say, okay, what is it we're doing? What are the key aspects here that make us different? What are our advantages? What are the things that some competitor is going to say, oh, really great, let's copy them, let's do this.
Yeah.
And make sure you've got a strategy that covers those things. And it's difficult because your patent attorney is not. I'm not making you any money. I'm helping you hopefully protect what you've got later.
Right.
But when you're talking to me, it's I know they sit down and they're like, that is a bill that's going to be showing up a month from now, and it's going to be it's going to be sizable, and that's money that we might spend on other things.
Sure.
So, I don't want to say I'm a necessary evil, but yeah, I mean, it's if you're depending on what space you're in, there are certain business models where your key is just get customers and grow.
Yeah.
Right. And if you're fast enough and you're first to market and you get your marketing together right, you'll do great. There's other ones that are slow and maybe you build a market, but then somebody says, well, there's no branding around this. There's no customer base. It's a cool little. It's a widget. Somebody else can make that same widget.
Okay.
If it's an unprotected thing, and Apple or Google or Oracle or Amazon or whatever comes along and says interesting, and they look and they go, well, why don't we got smart guys, just do that. They don't have any protection around it. Mm-hmm. In which case they'll eat your lunch.
Yeah. Okay. What's the deal with West Texas and patent litigation?
Well, West Texas is where the tumbleweeds live.
Oh, okay.
East Texas is the Eastern District of Texas is the premier venue for filing patent infringement lawsuits.
Okay.
Matter of fact, I haven't checked for the recent numbers, but as recently as like 2012, 2013, something like 25% of all patent litigation suits were filed in the Eastern District of Texas.
Okay.
It has a reputation. They have several judges there who do. It's one of those chicken and egg things. I don't know how it. I'm not actually aware of why it started. I'm sure there's a reason, but they have some judges and courts that are very patent savvy. They have a whole setup. They know how to handle patent infringement suits. They have gotten a reputation as being very patent friendly. Meaning, if I have patents and I want to sue somebody, I'm going to go there because the cases will tend to move fairly quickly. Mm-hmm. The judges tend to be not terribly sympathetic toward stays, meaning putting the procedure on hold, because there are procedures where you can take up. If you've been sued for infringement of a patent, you can go to the patent office and say, I don't think this patent should have been issued. And you can reopen that process. That process tends to be less expensive than a full-blown patent litigation. But there's a tendency for Eastern District judges. They have a reputation for not awarding a stay. So I go to the patent office and say this patent is invalid. They say that's all well and good. We're going to keep going.
Yeah.
And because of that speed at which things go, you can get kind of very rapidly into having to defend the patent, which becomes very expensive very quickly. If you're a accused infringer, you just map it out. You say, look, we're not going to be able to stay this by filing an inter partes re-exam with the patent office. We need to settle Figure out a monetary value on this and let's get it done.
Okay.
Which means, so and the reason that it's available is the venue rules where you can actually bring a lawsuit they require there to be some overlap. Something has to have happened in the Eastern District of Texas that is an infringing act for a suit to be filed there. But the hurdle to get to that point is very low. If you're an internet company, you have a website. If anybody has an internet-connected computer in the Eastern District of Texas and turned it on, you've got an infringing act, right? So it's a very the courts. There's been some push. There was actually a Federal Circuit case decided just last week that brought up this question about whether there should be a higher burden for establishing venue, and the court decided that nope, the status quo is fine.
Okay.
And now there's a push to actually bring there's a push in Congress to actually try and address this through legislation to make it more difficult to some greater nexus of activity to the venue.
Yeah.
But for now, there's a whole industry of law firms that are right there in the Eastern District of Texas who are the local counsel. So accused company might bring in their own patent attorney or their own patent litigators to defend, and then they're going to hire local counsel.
Yeah.
And it's an odd little. You wouldn't think that. I've been through Eastern Texas. It's certainly a nice enough area, but it's not what you would characterize as here is the high tech capital of the world,
right.
where we should be deciding these disputes.
Mm-hmm. Interesting. So, talk to me a little bit about every company that I've been with. This is even as a young engineer and then running companies. It's always been a head scratcher to me. I've always been very reluctant to pursue any patent litigation because I always wonder if the rewards are going to be worth the cost, because it's like super expensive, very time consuming, takes a lot of management time. I mean, in your experience, what have you seen? What would be like the acid test for saying, okay, we do need to pursue this even though it's going to be expensive?
Well, I think it comes down to where you are, what stage you're at, and like you said, it's expensive. I mean, estimates for sort of taking a patent infringement suit all the way to completion is something like, certainly in the millions in attorney fees. You might get out for 2, it might take you 4. So, it has to me, especially for an early stage company, if you're going to get to that point, first of all, you should be doing every effort not to get to that point early on, because, even if you've raised a lot of money, your next round of investors are going to, this lawsuit's going to be going on for a while.
Sure.
And I don't know very many wealthy people the smart wealthy people who want to stay wealthy don't want to throw their money into an open litigation, because it's an invitation to spend a lot of money. But, there are certain situations where you say, look, either we go stop this competitor from doing this, or we're out of business. And so it's not an easy conversation.
So it has to be like a life or death situation for a company, especially an early stage company, to say, okay, we really have to go out and try to enforce our will upon somebody.
And certainly, you could probably characterize it that. And it's certainly, litigation to me is it's the last stage in a license negotiation. Because even if you win a litigation, there are very few injunctions get issued. You basically win, and that means company B owes company A, maybe some damages, but then if they're going to continue doing what they're doing, they owe them a royalty.
Yeah.
So with that in mind, you say, well, I'm going to get at the end of this entire expensive process, there's going to be a royalty payment, maybe some damages, maybe some attorney fees if we're really, really lucky. But by and large, we're going to spend a lot of money to get here.
Yeah.
So it requires a sort of take a deep breath. It's very very emotional. It's like they're stealing our stuff.
Yeah.
But that said, you need to kind of do the math and say, well, you don't just immediately launch into a litigation. You're typically going to send them a letter and contact them and say, we believe you're infringing. You're going to kind of keep going up this ramp. Hopefully, at some point, you'll get to a point where we say, let's agree on something reasonable. It's certainly possible if you keep pushing it that the other side will turn around and say, oh, well, by the way, we have these patents that you infringe. Yeah. You'll get into that same situation.
Yeah.
So, typically the ones that go all the way to, full-blown litigation, there's got to be certainly not just a few $1 million involved. It's got to be, tens of millions at the bare minimum, and more likely hundreds or billions. Because those are the ones you read about, where
Sure.
Google and Oracle are fighting things out, or Apple's and Samsung are going to World War III.
Right.
And those are there's billions of dollars of potential revenue involved. So it makes sense. If you're a company with not even revenue positive yet.
Yeah.
It's a tough situation to be in, especially if the infringer is some big company. But you don't want to pick a fight with a gorilla when you're not a gorilla.
For sure. Now, talk to me a little bit about valuing patent portfolios. I mean, how do you go about doing that? And I've always kind of chuckled a little bit about this when I see these valuations coming out of these companies that you're in negotiations with. Our patent portfolio alone is worth $100 million. I'm like, well, maybe not.
The portfolio itself, without even looking at your portfolio, in most cases I'll say it's not worth that.
Yeah.
Your business as a whole, including the portfolio, including the customers you have, including the whatever activities you've done, it's a factor. So it may add in there. Typically, the market for patents you're never going to sell. There's certainly people who will be happy to buy your patent.
Sure.
There's these aggregators that whether they're non-practicing entities that are looking to license, or there's some other groups that are sort of they buy up patents sort of defensively, and allow it's sort of a subscription model. You can join this sort of group that goes and acquires patents to kind of have that ability to cross sue if you had to.
Sure.
But it depends. I mean, there certainly are very, very valuable patents. In the high-tech space, they're probably not as... It's hard to put a massive value on a single high-tech patent. On the pharma side, if you've got a patent that covers a drug that has a market of many millions of dollars a day in sales, that's a very valuable patent.
Yeah.
Right? Especially if it's on a specific compound, because it either is that or it isn't. If somebody's selling a generic and it's it got the same compound in it, guess what? You infringe. But on the high tech side, it's you want to have them. They're useful. They have some value. They're certainly a deterrent. But what they're actually worth at the end of the day is it's hard to say that patent is worth X. That patent in concert with hopefully your well-planned portfolio. It's a nice wall.
Okay.
But oftentimes what's inside the wall also has a lot to do with the value of your company. If you just have a really good wall and inside is a rundown shack that nobody visits, big deal.
All right, cool. So was there anything else that we missed or you wanted to talk about or mention to our audience of entrepreneurs out there?
No, that seemed like a pretty good overview. I don't know. Anything else you thought of?
No, I think that
we
was
ran
great.
out of questions.
Yeah, terrific. Well, thank you very much, Mike. Appreciate it. This is Patrick Henry, the CEO of QuestFusion with The Real Deal, What Matters.